Hello, Law students. This is a short lecture in which I will discuss these three topics. The first two are contextual. I will be discussing aspects of the Constitution and American history that your textbook addresses, but not with sufficient emphasis, in my opinion. The third is something the textbook does not cover pertaining to judicial decisions. So let's get started. First, we were colonies. Recall your learning of early American history. It may be from several years ago, but to understand constitutional law, you have to bear in mind the early days of American history, including its colonial history. Other than native people, our colonial ancestors were all either immigrants or slaves forcibly brought to the North American continent. They were all subject to British rule. The King of England permitted the colonists to settle in North America, subject to his rule and the laws enacted by the English government known as Parliament. And when I say Parliament, don't think like democratically elected representatives. That's not who they were. They were the nobility of English society, chosen by the nobility of English society to make laws for the British Kingdom. Um, they were known as Parliament. The laws they made, English common law, the law of Great Britain, applied to the colonists. It heavily influenced the developing common law in the American colonies. You might still see references actually to English common law when you read some of the cases in this class, because it originated with English common law was the origin of American common law. It started there and then kind of became something of its own. Back to the important point. There was no constitution for the government of Great Britain to protect the liberties of its citizens. The colonists were all subject to the will and whim of the king. Toward the middle of the 1700s, as you should have learned from the reading assignment, the American colonists grew dissatisfied with Parliament's laws, with what they believed was an abuse of power by the king. But the British government was their national government, and they were ready to get rid of it, even if doing so meant fighting a long and bloody war. When the colonists dissolved their political relationship with England, they asserted themselves as 13 separate states. If you read the Declaration of Independence, which I don't have on the slide here, but at the very end, that's exactly what it says. That the signers of the Declaration of Independence, acting on behalf of all 13 states, they refer to themselves as free and independent states. So we've just gone from being colonists, and the national government was the British government, to states without a national government. So we were 13 separate states, formal political states to be recognized by all political states worldwide. Each state had its own constitution, had its own government, that government helped elect delegates to send to a continental congress, and that Continental Congress was in charge of fighting the Revolutionary War and then ultimately writing the first governing document forming the first national American government known as a confederation. The document they wrote was called the Articles of Confederation. The document, as you see this big word, it's in all caps, uppercase, big word, confederation. That was the nature of the national government they formed. And it's titled their perpetual union between the states. So you can still see the emphasis being on the state governments forming a union. Because the Articles of Confederation did not grant the national government enough power, it was dispensed with about 13 minutes later, and delegates were sent again they were sent to Philadelphia together to form a more perfect union. Of course, we're referring to their writing of the Constitution. So now we've gone from being 13 separate states, now look at this title, We the People. Now we become, through the Constitution, a nation of people, no longer just a union of 13 separate states. We are now a nation of people. That's our more perfect union. But not surprisingly, perhaps all along, because of their history with Great Britain, the people of America wanted their new national government to be relatively unobtrusive. Um, Transportation was very primitive at the time. People never left their home state, never saw, most people never left their home state, never saw or knew much about any other state. So their state was their nation. Their civic attachment went first to their state and only secondly to their nation. They look to their state governments for policy making in every single area, but they look to their national government just for the most national of policies. So, fighting wars, trade with foreign nations, regulating interstate trade, those types of things. Few, if any, people could have fathomed the extent and power of the national government that we have today. So much has changed. Um, but fortunately, the drafters of the U.S. Constitution knew their own limitations. They knew that they could not possibly foresee what our nation would become. So what they wrote has to be studied in the context of those fallible men sitting in a stuffy room 240 years ago, writing a constitution that was based on even older documents. In your textbook, it talks about how the principles of the Constitution are drawn from even the Magna Carta. So these men were entrenching principles that had existed for centuries, and they hoped at least would stand the test of time into the future. They weren't trying to make predictions or write detailed laws. So the Constitution doesn't have very many rules or laws at all. What these men were doing was entrenching these broad principles and allowing future generations to refine and extend those principles, apply them as they saw fit in their own day and time. So now let's step back and look at the big picture of the U.S. Constitution. And so I'll ask you this question. What is the U.S. Constitution? Now, your textbook, probably several classes that you've taken in school over the years, have taught you the answer to that question. But I want you to think deeper about it for this class. The U.S. Constitution formed a government. That was its primary purpose, to form a more perfect union. Now, I don't want to put too much emphasis on the writing part of this. The agreement of any people to accept the limited authority of elected officials, to follow a legal code of acceptable behavior. In effect, that does form a political state with a functional government. But when you write it all down, it becomes something even greater. You have to look, you have this document that you can look at, refer to for years to come. Subsequent generations can look back at that document and know what the rules were for the formation of their nation, what their national government ought to do or not do. So the law, the government's powers, has become entrenched. So the U.S. Constitution was our ancestors' effort to entrench the nature of our national government. Most everyone got to read it, not slaves, unfortunately, but most everyone had a vote in whether it would be followed. That is known as the principle of popular consent. It is the very foundation of democracy. So the U.S. Constitution then is this entrenchment of America's form of democracy. It defines what powers our national government will have and what powers it will not have. There are more limitations on government power than there are grants of power in this document. The primary function of it is to define and limit the power of the national government. Always start your analysis off that way. No branch of government can exercise a power unless that power is authorized by the Constitution. The original articles of the Constitution outline the structure of the national government and list the powers that each branch will have. They also include certain specific limitations on government power, and they identify certain liberties and rights of the people that the government cannot infringe. The original 7 articles did all of that before there were any amendments at all. The first 10 amendments you know as the Bill of Rights. They were not part of the original Constitution. They were ratified 2 years later. They were a concession to Anti-Federalists, imposing additional limitations on the power of Congress. So you'll read about that in your textbook. But bottom line, the U.S. Constitution is the entrenchment of the people's will for what powers their government has or does not have. It is there to protect the people from abuses of power by their elected leaders. That is its purpose. What do you need to know these things in order to study constitutional law? Let me just end these 2 topics by circling back around to that point. To understand any written document, you have to understand its context. You can't interpret the meaning of the written word unless you know the context of its writing. So what Module 1 is meant to show you is the context of the U.S. Constitution. As you're studying the material for this module, here's what you need to learn. Learn the Constitution's context first, that history lesson. Then learn its structure. Look at what it formed. Then look at the big picture of what it contains. So what does Article 1 provide? What does Article 2 provide? And so on for all 7 articles. And then we'll start studying the details of those articles in subsequent modules. Now we'll move on to our last topic. And as I mentioned earlier, this isn't in your textbook, so listen up. The textbook does mention that this one principle, this first principle, the courts are reluctant to overrule their decisions. That's known as the principle of stare decisis. But guess what? Cases do get overruled sometimes. Sometimes they are criticized, if not outright overruled. Sometimes courts are asked to apply a case precedent, but choose not to do so because they find that precedent distinguishable from the current dispute before them and choose not to follow the prior court's holding. That type of negative treatment of a case takes away its value as precedent. So when attorneys or paralegals are trying to make arguments with case law precedent, they need to know whether their case, the one on which they're relying, is still good law, still relevant and applicable to this case. So that's what this point is about. How do you know what is still good law? Now, when I was in law school, the internet existed. I'm not that old, but it wasn't yet the storage of all human knowledge like it is today. Legal research was done in books that you found in brick and mortar libraries. It took a long time, was very tedious. But to find a case, we would use the annotated headnotes that case law editors compiled into huge volumes of books. So we're using books to find the cases, to read the cases, and then to also verify that the cases we wanted to use were still good law, that they had not been overruled or criticized by any other court. The books that contained that history and treatment was called Shepard's Citations. So that's just an image of just a very, very small part of Shepard's Citations. It is a huge volume of books. But that process of checking the historical treatment of a case was called Shepardizing the case, coming from the title Shepard's Citations. You have, you will have, when you go into a legal practice, if you aren't already there, an ethical obligation to determine the treatment of a case and to inform the court if the case on which you're relying has been overruled or treated negatively by other courts. Although the process now is done with electronic databases, it's still called Shepardizing. So that's what we'll refer to it as Shepardizing. There are many different internet databases of case law. This is something your textbook does touch on. Fortunately, the 2 primary ones used by attorneys and paralegals, Westlaw and Lexis, they show how a case precedent has been treated since the date of its decision. They'll give it a red flag or a stop sign if a case has been overruled. Oh, I have a picture here. Hold on. This is a Westlaw screenshot of a Westlaw case here. So you see the red flag up here. So that means that this case was overruled by a subsequent case. So that means red flag warning, this is no longer good law. A yellow flag in either place or a yellow light, if you're in Lexis, it looks like a light. A yellow light will be there if your case has been criticized or distinguished. And then there will be a green flag, like green for go, if your case has been followed and applied. So it's really good law when you see that green flag. Westlaw and Lexis will give you a list of every single case that has mentioned your case. And it'll even go further than that and give you every article, every book, every journal, anything that has ever used your case for any purpose will be in that list. So it's extremely helpful tool. And you'll need to know how to use Westlaw and Lexis if you pursue a career in law. And I think several of you in this class are doing so. So you'll be expected to shepherdize every case you present to a court in support of your legal arguments. Landers Library provides students with free access to Westlaw. That's where I got this from, this what I took a screenshot of. And our learning module includes a small little Westlaw research project in which you'll practice this. You'll practice using the head notes and shepherdizing a case. So that's all for this lecture. As I said, this was just a short topical lecture, not meant to cover everything in your reading. So you do need to study your textbook carefully, take notes, and then get started on your assignments.